Cannabis has been legal in Illinois for years now. You can walk into a dispensary in River North, Logan Square, or anywhere in Cook County, buy your weed legally, and head home. But here is the massive trap that catches thousands of drivers by surprise. Legal to consume does not mean legal to drive. If you get pulled over in Chicago or the surrounding suburbs with cannabis in your system, you can still easily end up in the back of a squad car facing a Class A misdemeanor. Today, we're breaking down exactly how Cook County handles marijuana DUI, the scientific flaw in the law that could ruin your driving record, and what you need to do if you're flashing red and blue lights in your rearview mirror. When it comes to alcohol, everyone knows the legal limit is 0.08%. But for weed, Illinois uses two entirely separate pathways under the law to convict you of a DUI. The first is what we call a per se violation. Under Illinois law, if a chemical test shows you have 5 nanograms or more of THC per milliliter of whole blood, or 10 nanograms in your saliva or urine, you are automatically guilty of a DUI. It does not matter if you feel completely sober. If you're over that number within 2 hours of driving, it is a crime. But here's the second pathway: impairment. Even if you are under that 5 nanogram limit, an officer can still arrest and charge you if they believe your driving was noticeably impaired by cannabis. Now, let's talk about the giant elephant in the courtroom. The science behind THC testing is fundamentally flawed. With alcohol, a breathalyzer gives a pretty accurate picture of how drunk you are right now.
Okay, that's sufficient. You can relax.
But THC is fat-soluble. It attaches to your body's fat cells and lingers. If you are a heavy or daily smoker, you could easily test above that 5 nanogram limit days or even weeks after the last time you actually used cannabis. You aren't high, you aren't impaired, but according to Illinois law, you are a drunk driver's legal equivalent. Crucial exception for medical card holders. If you are a registered medical cannabis patient in Illinois, you are actually exempt from that automatic 5 nanogram per se limit. However, the police can still charge you if they can prove you were actively impaired while behind the wheel. If you are arrested for a cannabis DUI in Cook County, you are immediately fighting a war on 2 entirely different fronts. The criminal case is punishable by up to 364 days in jail and up to a $2,500 fine for a first offense, and a civil case involving the suspension of your driver's license. Statutory summary suspension kicks in automatically 46 days after your arrest. If you take the chemical test and fail it by going over 5 nanograms, your license is automatically suspended for 6 months. If you refuse to take the blood, saliva, or urine test entirely, your license is suspended for 12 months under Illinois' implied consent laws. And don't count on Cook County prosecutors dropping these charges lightly. The state's attorney takes DUI enforcement incredibly seriously, using specialized officers called drug recognition experts to build cases against drivers based on roadside physical indicators like eye movement and balance. Because the science of cannabis testing is so messy, these cases are incredibly beatable with the right defense strategy. An experienced local attorney can challenge the officer's initial reason for stopping you, poke holes in the roadside field sobriety tests, or dispute the timing of the blood chemical test. If you or a loved one is facing a marijuana DUI, charge in Chicago or Greater Cook County. Don't just plead guilty. Reach out to a qualified criminal defense attorney, Mitch Furman, who knows the local court system inside and out. If this video helped clarify how the law actually works, drop a like, hit subscribe for more local legal updates, and leave any questions in the comments below. Drive safe out there.